Hello everyone, welcome to Courts Today by Live Law, your go-to source for the latest and fastest legal updates. I am your host Urvashi Chauhan, here to bring you daily developments, landmark judgments, significant rulings and expert insights from the world of law. Let us begin with the headlines and a concise overview of the top stories, and after that we will delve into the full details. While hearing the Badlapur fake encounter case, the Bombay High Court has remarked that it is hard to accept that cops could not overpower the accused and shootout could be avoided. The Supreme Court has cautioned that judges should avoid casual comments which are misogynistic and prejudicial to any community. A Bengaluru court has directed the Mysore Lokayukta police to investigate MUDA case involving CM Siddaramaiah. The top court has expressed doubts about the reasoning applied by the NCLAT in approving Byju's settlement with BCCI. The top court today questioned the Enforcement Directorate on low conviction rate in PMLA cases while granting interim bail to Saumya Chaurasia. The Supreme Court has refused to entertain a plea challenging voter eligibility criteria in Delhi Bar Association elections, allowing the petitioner to approach the High Court. A division bench of the Bombay High Court today heard the pleas by father of Badlapur school sexual assault accused who allegedly died in a fake encounter on Monday. The deceased had been booked in a POCSO case for allegedly sexually assaulting two minor kindergarten girls in a school at Badlapur in Thane. The 24-year-old accused, who was a sweeper in the school, died in retaliatory firing after he allegedly snatched a policeman's gun in a van and opened fire. His father has approached the court seeking an investigation into the matter as well as registration of FIR against the erring police officials. During the hearing, the bench noted some lacunae in the initial probe by the crime branch, Thane Police, and raised several questions regarding the probe, especially the forensic evidence at the site. It remarked that it was hard to believe that the accused, not being a strong man, could not be overpowered by the police officers present with him. The court questioned the location, medical response, and handling of the accused, who was shot after an alleged scuffle with the police. Justice Chavan expressed skepticism about the claim that the accused, described as a weak man, could have loaded and fired a pistol, noting that using such a weapon requires strength. The court also asked about standard procedures, whether the accused was handcuffed, and if fingerprints were taken from the pistol. In response, the Chief Public Prosecutor Hiten Venegaonkar explained that the incident took place near a small town surrounded by hills and the injured were taken to the nearest hospital 25 minutes away. He confirmed that the accused's body was sent for post-mortem at 8 a.m., which was video recorded, and that the cause of death was a bullet wound to the head. Regarding the scuffle, Venegaonkar stated that the magazine came out during the altercation, causing the weapon to load and be ready to fire. He also confirmed that the accused was initially handcuffed but was unshackled when he asked for water. The court further stressed on the need of an impartial probe, adding that while it was not doubting the police, however, it wanted to get to the truth. It asked the police to come clean so that there are no inferences drawn by the people. In the next update, a 5-judge bench comprising CJI D.Y. Chandrachud and Justices Sanjeev Khanna, B.R. Gawai, Suryakant and Rishikesh Roy today heard the suo motu matter relating to the viral clippings of the controversial comments made by Justice V. Srishanandan of Karnataka High Court during hearings. In one video, he was seen referring to an area in Bangalore which is apparently Muslim-dominated as Pakistan. And in another video, he was seen making objectionable remarks to a woman advocate in a matrimonial dispute. The court, referring to the High Court Registrar General's report, noted that the remarks were unrelated to the case. The CJI, expressing concerns about the remarks, said that no part of India's territory can be called Pakistan as it goes against the country's territorial integrity. The bench expressed disapproval of the judge's comments about a specific gender and community, stating that such remarks should be avoided. It cautioned that judges should avoid casual comments which are misogynistic and prejudicial to any community and must be guided by only the values which are enshrined in the Constitution. However, the top court decided not to pursue the matter further in light of regret expressed by the judge in the open court after the Supreme Court's intervention over the viral video clips. At the same time, the court made several significant observations on the need for judges to express restraint, particularly in the age of electronic media where there is wide reportage of the court proceedings. The CJI also said that the controversies created due to circulation of objectionable remarks made by the judges cannot be a reason to shut down the live streaming of court proceedings. He said, and I quote, that answer to sunlight is more sunlight, not to suppress what happens in the court. This is a very important reminder to everyone. The answer is not to close doors and shut down. A special court in Bengaluru today directed the Mysore Lokayukta police to investigate the alleged Mysore Urban Development Authority scam involving Chief Minister Siddaramaiah, his wife and others. The special court judge Santosh G. Bhatt passed the order on a private complaint. It ordered the police to investigate the matter and submit a report before the court within 90 days. This comes a day after the Karnataka High Court dismissed the petition filed by Siddaramaiah seeking to quash the sanction granted by the governor to prosecute him in the alleged scam. During the pendency of the hearing of the petition, the court had, by way of an interim order, stayed for the proceedings before the trial court on the private complaints. The High Court, while dismissing the petition, dissolved the interim order. A Supreme Court bench led by CJI D.Y. Chandrachud heard today the challenge to NCLAT's decision by a US-based lender, Glass Trust Company LLC, in appeal. Last month, the court had stayed the order of the National Company Law Appellate Tribunal, which upheld the settlement between Byju's and BCCI in relation to Byju's 158 crore dues to the latter. The stay order was passed on Glass Trust Company's appeal, which opposed the Byju's BCCI settlement and led to revival of insolvency proceedings against Byju's. Senior advocate Shyam Devan, representing Glass Trust, argued that the NCLAT wrongly used its inherent powers under Rule 11 to approve the settlement and end the insolvency proceedings. Glass Trust opposed the settlement, claiming that the money paid by Riju Ravindran, who is Byju Ravindran's brother, was suspicious and involved round-tripping. Senior advocate Abhishek Manu Singhvi, representing Byju's, argued that the insolvency petition was filed by BCCI itself and there was nothing improper in closing it based on the settlement. He also stated that Glass Trust has no grounds to challenge the settlement as it was made with BCCI using the personal funds of Riju Ravindran. Senior advocate N.K. Kaul, also appearing for Byju, submitted that there was nothing wrong in approving the settlement when the insolvency proceeding has not progressed to advanced levels. He said that the Glass Trust was trying to piggyback on proceedings initiated by another debtor, and if they wanted to recover, then they should file their own application. The court, however, expressed doubts about the reasoning applied by NCLAT, saying that the tribunal did not appear to have properly applied its mind. The CJI questioned as to how one creditor could choose to settle with a single promoter when the total debt is so large. The CJI highlighted the inconsistency in settling only with BCCI, emphasizing that this arrangement seemed to be made using personal assets despite the total debt reaching 15,000 crores. The hearing in this matter will continue tomorrow. Stay tuned. In an important update, the Supreme Court has today granted interim bail to Chhattisgarh's suspended civil servant Saumya Chaurasia in a money laundering case, taking into account factors including the amount of time spent in custody and the non-framing of charges. Chaurasia, the former Deputy Secretary to ex-Chhattisgarh Chief Minister Bhupesh Baghel, is accused in a money laundering case relating to coal scam. She has been in jail for over 1 year and 9 months now. The bench of Justices Suryakant, Dipankar Datta and Ujjal Bhuya was dealing with her challenge to the High Court's order dismissing her third bail application. The court, without expressing any opinion on merits, granted her interim relief with a view to give an opportunity of elaborate hearing to the parties on the next date. It further directed that the state government shall not reinstate Chaurasia in service merely because she has been released on interim bail. She shall continue on suspension with some other conditions imposed. Significantly, during the hearing, Justice Bhuya today pulled up the Enforcement Directorate for its low conviction rate and insistence on keeping people behind bars without even framing charges. At the same time, Justice Datta expressed surprise at an observation in the impugned judgment that trial had not started because warrants could not be executed. The Supreme Court today refused to entertain a plea challenging certain voter eligibility criteria to vote imposed by the Delhi High Court in Delhi Bar Association elections. The petition challenged two new eligibility criteria for voting in the upcoming Bar Association elections imposed by the High Court after accepting recommendations of a committee appointed by it. These conditions require, firstly, that voters must hold an identity card or proximity card to cast their vote in Bar Association elections, and secondly, advocates must have made at least 12 court appearances in the previous year by 31st July of the election year. In the case of law firm advocates, proof of remuneration for 6 months certified by an equity partner must be submitted. The High Court issued the judgment to enforce the one bar, one vote principle, which mandates that each advocate can vote in only one Bar Association election. The petition argued that the new voter eligibility conditions infringe on the voting rights of members who had already qualified under the Bar Association's rules, claiming that their retrospective enforcement was arbitrary. It also stated that these conditions were imposed without proper consultation with all stakeholders, particularly the bar associations. The petition further contended that the High Court did not recognize that proximity cards are simply for regulating court entry, and having multiple cards or different bar associations does not undermine the one bar, one vote principle. Additionally, it claimed that requiring law firm advocates to disclose proof of remuneration for 6 months violates their right to privacy, as advocates are uncomfortable sharing financial details without a clear rationale linking this disclosure to voter eligibility. But the bench of Justices B.R. Gawai, K.V. Vishwanathan and P.K. Mishra disposed of the petition and granted liberty to approach the High Court to seek modification. For more details on the cases mentioned here, please visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Don't forget to like, share and subscribe to our channel. You can support us by donating through the thanks button at the bottom of our videos or by becoming a member for just 89 rupees per month.